Hello everyone, my name is Amber Rouse Holloway, and I'm a partner here at Secrets Wardle at our Troy office location. You are now listening to the November 2020 episode of my PIP Monthly. Our November 2020 topics include a case law update of Mullen v. Progressive, then we'll move on to AdvisorCare Health Solutions v. Auto Owners, and then on to Bonham v. Farm Bureau General Insurance Company. And lastly, we'll discuss the Barnes v. 21st Century Premier Insurance Company case. Moving on to our trending topics in PIP litigation, I will discuss testimony of biomechanical engineers and, generally speaking, PIP trials. First up for our case law update is the case of Mullen v. Progressive, the unpublished opinion of the Court of Appeals issued October 22, 2020. Interestingly enough, this case was handled by our very own Secrets Wardle attorneys in both the trial court and on appeal. This case piggybacks off of the Bazzi v. Centennial Court of Appeals case, which confirmed that in no-fault cases, the innocent third-party rule was abrogated and insurers may rescind automobile policies based on fraud in the application for insurance, even when an innocent third party seeks PIP benefits. Bazzi went on to further note that rescission is an equitable remedy, but not an absolute right. Therefore, before the claim of a third party can be dismissed, the courts must balance the equities. The court in Bazzi never really discussed exactly how to balance the equities, just that it needed to be done. But Mullen v. Progressive goes on to discuss 5 factors that should be considered. As a background, in Mullen, the plaintiff was injured in an automobile accident involving an unidentified vehicle. At the time of the accident, plaintiff's driver's license was suspended due to unpaid traffic tickets. The vehicle that plaintiff was driving belonged to his wife, Valerie Mullen, and was covered by a Progressive policy. Valerie made the claim for PIP benefits to Progressive on behalf of her husband, the plaintiff, and while reviewing the claim, Progressive discovered that Valerie failed to list her husband as a driver on the insurance application. Valerie also failed to disclose that the two were married and were members of the same household, and that her husband would be driving her car. After discovering that plaintiff was driving Valerie's car with a suspended license, Progressive went on to rescind the policy, declared it void, and returned all the premiums. Progressive cited reasoning stating that the insured concealed, misrepresented, or made incorrect statements or representation regarding a material fact or circumstances, and they did so in their application for insurance. After Progressive rescinded the policy, plaintiff filed an application for PIP benefits through the MAIPF. However, the MAIPF did not assign the claim to a servicing insurer, which prompted plaintiff to then sue Progressive. Again, Progressive was represented by Secrets Wardle in both the trial court and on appeal. Plaintiff claimed that Progressive was liable for all the PIP benefits under the policy, or in the alternative, that the court entered a declaratory judgment stating that the MAIPF was required to assign this claim out for PIP benefits. Progressive went on to move for summary disposition and indicated that Progressive was not liable for the PIP benefits because the policy was void in this instance. The trial court went on to agree with Progressive's position, and plaintiff appealed, and the Court of Appeals went on to affirm this decision. The Court of Appeals argued that Valerie's misrepresentation was indeed material. A misrepresentation is material if a reasonably careful and intelligent underwriter would have regarded the fact or matter communicated at the time of the affecting the insurance as substantially increasing the chance of loss insured against so as to bring about rejection of the risk or charging of an increased premium. Basically, if they would have known this information, would the premiums have been different, or would they have even insured Valerie? The answer to that question here is no. Because Valerie failed to identify plaintiff in her insurance application, she yet failed to identify her marital status and made no mention that plaintiff as either her husband or a member of her household, Progressive had no opportunity to evaluate plaintiff as a potential driver. The court found that there was no question of a material fact that Valerie's statements on the policy were false and that she knew that they were false at the time that they were made. Therefore, the court found that the rescission was indeed proper. The court then began to balance the so-called Markman factors to determine whether Progressive's rescission would sever the rights of plaintiff, an innocent third party. Those factors are: 1, whether the insurer could have uncovered the subject matter of the fraud before the innocent third party was injured; 2, whether the relationship between the fraudulent insured and the innocent third party suggests the third party had knowledge of the fraud; 3, whether the innocent third party's conduct played a role in the injury-causing event, the accident; 4, whether the third party has an alternate avenue for recovery if the insurance policy is indeed rescinded; 5, whether policy enforcement only relieves the insurer of what would otherwise be the insured's personal liability to the innocent third party. Ultimately, the court found that the factors 1 through 4 all favored Progressive. Factor number 5 didn't apply to this instant matter. As such, the trial court's granting of Progressive's motion for summary disposition was affirmed by the Court of Appeals. Moving on to the case of AdvisorCare Healthcare Solutions v. Auto Club Owners Insurance Company, unpublished opinion from the Court of Appeals issued October 15, 2020. Here, the issue of whether an infection and a subsequent amputation arose out of injuries originally sustained in the motor vehicle accident are discussed. Under MCL 500-3105, Section 1, an insurer is only liable to pay benefits for accidental bodily injuries arising out of the ownership, operation, maintenance, or use of a motor vehicle as a motor vehicle. This is important because the Michigan Supreme Court has interpreted this section to require that a causal connection between the injury and the use of a motor vehicle as a motor vehicle must be more than incidental. By way of background, the accident that's the subject matter of this opinion occurred in November of 2016, in which the insured claimant Vivian Mazde lost control of her vehicle and hit a tree. She sustained a number of injuries, including several deep lacerations and traumatic wounds to her leg. Subsequently, she traveled to Mississippi to visit family, at which time she sustained a number of falls and suffered more injuries to that same leg she injured in the accident. Her treating physician, Dr. Thomas Watkins, testified that he expected that the falls were attributable to the accident because she was not having any difficulty walking before the accident. When she returned to Michigan, she was then diagnosed with an infection in that same leg that was injured in the accident, which ultimately led to an amputation of her left leg, unfortunately. Her doctors attributed the infection and amputation to the subject motor vehicle accident because it caused her decreased mobility. The defendant's insurer in this matter retained an expert who opined that the infection was not related to the accident and thereafter denied her claim for attendant care benefits. The court in AdvisorCare relied on the McPherson case, which is McPherson v. McPherson, and held that there was no evidence to suggest that the injuries that the claimant sustained to her left leg from the accident caused the infection and the subsequent amputation, and therefore did not arise out of the injuries sustained in the subject motor vehicle accident. The court determined that there was absolutely no evidence that the first injury caused the second injury in a direct way. Interestingly enough, it was held that she did not contract an infection from the accident, but rather she contracted an infection during one of her falls in Mississippi. The court ultimately held that this type of causation was explicitly rejected, meaning that the falls that the claimant suffered were too remote from the automobile accident to permit a finding of a causal connection between the accident and infection/amputation were more than incidental. The next case I would like to discuss is Bonham v. Farm Bureau General Insurance Company, another unpublished opinion of the Court of Appeals issued October 15, 2020. Here, the court ultimately vacated the trial court's order granting summary disposition to Farm Bureau. In doing so, the court affirmed that an insurer's anti-fraud provision does not constitute grounds for rescission based on material misrepresentations made during litigation. This case differs from the Mullen case we first talked about, as in Mullen, the insured, which was plaintiff's wife, made the misrepresentation in the act in preparing the application for insurance. Here, the misrepresentations were made during litigation. The facts of this accident arose out of a first-party action for no-fault benefits brought by the underlying claimant as well as 3 other intervening medical providers stemming from an October 28, 2016 motor vehicle accident. Here, the plaintiff alleged that he sustained a brain bleed, broken jaw, ribs, fractured hip, ligament damage, and injuries to his neck and back as a result of the accident. Between November 2016 and September 2017, the claimant submitted reimbursement forms from household services allegedly provided by his sister. These forms later go on to be the focus of plaintiff's misrepresentation. Ultimately, Farm Bureau places plaintiff under surveillance, and during surveillance, plaintiff was observed shoveling snow, walking without a cane, shopping, washing his vehicle, and carrying groceries. He also was observed performing yard work, carrying heavy objects, and lifting lawn bags. All of the activities plaintiff was witnessed doing were activities he alleged his sister had performed for him following the accident. Farm Bureau then goes on to file a motion for summary disposition, alleging that the plaintiff was precluded from recovering PIP benefits on the basis of fraud. Farm Bureau, of course, relied on its anti-fraud provision in its insurance policy and argued that plaintiff made material misrepresentations in his claim for replacement services and also made fraudulent statements during his deposition about his pre- and post-accident medical condition. Most importantly, Farm Bureau did not argue, which differs from the Mullen opinion, that plaintiff committed fraud in his application prior to the lawsuit being filed. Rather, defendant argued that plaintiff's medical providers should be dismissed because the providers stand in the shoes of the plaintiff. Ultimately, the Court of Appeals reversed the trial court's order and relied on its recent decision in the Haydaw v. Farm Bureau case, which is another Court of Appeals opinion. In Haydaw, the court held that the fraud provisions in a no-fault insurance policy do not provide grounds for rescission based upon false statements made by an insurer during the first-party litigation. The Haydaw court opined that the misrepresentations made during litigation cannot void an insurance policy because the claim had already been denied. As such, any misrepresentations amount to discovery misconduct. The court in Haydaw further reasoned that material misrepresentations made during litigation cannot satisfy the elements of fraud because the statements were made with the intention that the tier of fact, not the insurance company, will act on those statements in awarding benefits. Interestingly enough, the court in Haydaw took the unprecedented step of invoking the first breach rule, finding that an insurer, by denial of the claim, was the first party to breach the contract, not the plaintiff by the material misrepresentation. And lastly, for our last case law update of the month is the case of Barnes v. 21st Century Premier Insurance Company. Here, the issue of domicile is discussed, and the Court of Appeals affirmed the jury's finding that the plaintiff was domiciled in the same household as his grandparents on the date he was injured. The court affirmed the trial court's denial of the motion for summary disposition brought by defendant. In Barnes, the plaintiff suffered injuries in a car accident on September 27, 2013, at which time his grandparents held a no-fault policy issued by the defendant. At the time of the accident, Barnes lived in an upstairs unit of a 2-story home and his grandparents lived downstairs. Here, the defendant argued that the plaintiff did not live with his grandparents, and conversely, the plaintiffs argued that the evidence showed that the 2 units constituted one household for the purposes of MCL 500-3114. Here, each unit had its own entrances, living areas, gas and electric meters, and furnaces. The 2 units were also separated by an interior door equipped with a deadbolt. Barnes paid his own gas and electric bills and half of the mortgage and water bills. He was not noted on the insurance policy application on the defendant. However, another grandson who lived with the grandparents in the downstairs unit was noted, not the plaintiff who lived upstairs. Plaintiff submitted evidence that only family members had lived in the entire home, so both the upstairs and downstairs unit, for approximately 50 years, and the only bill he paid was the cable bill, and he, generally speaking, wandered freely between the 2 units. The home had only one address and one mailbox. The family sometimes shared meals together, and the grandma would occasionally use the stove in the upstairs unit, plaintiff's unit, to cook meals, and he had to abide by house rules regarding noise, company, and other matters. Here, the Court of Appeals erred that the trial court did not err by denying defendant's motion for summary disposition. The evidence supported that the plaintiff and his grandparents formed one family unit, not two family unit. The Court of Appeals said the key was not the physical structure or design of the house itself, but rather the conduct and behavior of the people living in the house. This inference is extremely important given that the deposition in this case was likely taken early on, and these questions had to be asked regarding the structure and the actual activities of the individuals living in the home. It seems as if more inference should be placed on the activities than the actual structure. Here, the plaintiff had no other place of lodging. He was living in the same house as his grandparents. He intended at the time of the accident to remain in the upstairs unit of his grandparents for an indefinite length of time, and he also had a close and informal relationship with his grandparents. And moving on to our trending topic in PIP litigation for November 2020, I wanted to discuss the testimony of biomechanical engineers. This testimony is typically governed by MRE 702 and MCL 600-2955. Under MRE 702, if the court discovers that a scientific, technical, or otherwise specialized knowledge will assist the tier of fact to understand some evidence or to determine a fact and issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion, or otherwise, if the testimony is based on sufficient facts or data, the testimony is the product of reliable principles and methods, and also the witness has applied the principles and methods reliably to the facts of the case. Under MRE 702, the trial court must function as a gatekeeper in making decisions regarding the admissibility of scientific evidence and ensuring that expert testimony meets the rule's standard of reliability. Testimony of a biomechanical engineer is also governed by MCL 600-2955, which provides that in an action for the death of a person or for injury of a person or property, a scientific opinion rendered by an otherwise qualified expert is not admissible unless the court determines that the opinion is reliable and will assist the trier of fact. In making that determination, the court shall examine the opinion and bias for the opinion, which basis includes the facts, techniques, methodology, and reasoning relied on by the expert, and shall consider all of the following factors. A, whether the opinion and its basis have been subjected to scientific testing and replication. B, whether the opinion and its basis have been subjected to peer review. C, the existence and maintenance of generally accepting standards governing the application and interpretation of the methodology or technique, and whether the opinion and its basis are consistent with those standards. D, the known or potential error rate of the opinion. E, the degree to which the opinion and its basis are generally accepted within the relevant expert community. F, whether the basis for the opinion is reliable and whether experts in that field would also rely on it. And G, whether the opinion or methodology is relied upon by experts outside of the context of litigation. In determining the admissibility of expert testimony, the trial courts shall consider all of the factors listed in MCL 600-2955. The party offering the expert testimony has the burden of satisfying the preconditions established by MRE 702 and MCL 600-2995, not the party that is not offering the expert testimony. And a court must consider all of the statutory factors in making the admissibility rule. But evidence may be admitted even if some of the factors do not support admissibility. It's important to note that an expert opinion upon only hypothetical situations is not permitted. The expert must actually apply their methodology to the facts of the accident. But given that, the law does not require that an expert witness have to have a full understanding of every fact regarding the accident or every fact in a case at all. Only that the expert testimony set forth specific facts that would support a reasonable inference of logical sequence of cause and effect. However, in setting forth the specific facts, there must be facts to support the opinion of the expert. In a recent Court of Appeals unpublished opinion issued October 29, 2020, in the case of Robin Harcrater v. Sheldon Hayes and B&M Ashman, Inc., the plaintiff argued that the biomechanical engineer should have been precluded from testifying because she did not have sufficient understanding of the factual circumstances of the case to provide a reliable expert opinion. The plaintiff also argued that the trial court erred in permitting the biomechanical engineer to provide expert testimony because she was not a medical doctor. Here, the court disagreed. As I said in the previous slides, an expert is not required to know all of the facts of a case in order to provide a reliable expert opinion. Again, the court here reasoned that the law does not require an expert witness to have a full understanding of every fact in a given case, only that the proponent of the expert testimony set forth specific facts that would support a reasonable inference of a logical sequence of cause and effect. The facts specific to this case, the plaintiff argued that the expert was not a medical doctor and that she should not be able to opine as to plaintiff's medical condition. However, the court did note that plaintiff is correct that an expert in biomechanics is not permitted to testify regarding medical causation of a specific injury for a specific person. A biomechanic expert is permitted to testify about whether a claim focuses, when applied to a human body, could result in certain injuries. It should be noted that testimony in that regard must be very narrow and limited. So a biomechanical engineer could testify that this type of force that took place in the accident could cause an injury, but a biomechanical engineer is not able to discuss whether the specific injury was medically caused for a specific person. Specifically, the expert in this case testified that a change of speed and direction to the vehicle that could not have caused a herniated disc. The expert did not testify that plaintiff did or did not actually suffer a herniated disc, but did testify that the specific force could not have resulted in a herniated disc. Although this is a narrow distinction, it is indeed a distinction, and the court held that the biomechanical engineer in this case was permitted to testify. And that is all I have for our November 2020 episode of My PIP Monthly. Please feel free to contact me with any questions, comments, or concerns. Again, my name is Amber Rouse Holloway, and I'm a partner here at Secrets Wardle at our Troy location. Thank you.